Evening, I'm Todd Kotler. I'm a family relations lawyer for Gruber, Haren, Thomas and Company in Canton, Ohio. I practice throughout Northeast Ohio, and I am pleased to talk to you a little bit about family relations law. I'll be posting these videos from time to time, perhaps more often, depending on the feedback I get from you, the viewers out there in YouTube land. Today's question comes from someone who asks whether they have to continue to pay alimony when their ex has an apartment, but the kids and him are spending every night at his girlfriend's. This is not an uncommon question that I get uh, when talking to prospective clients. My answer for this person, as to all of you, would be, well, it depends. How much are they paying in support, and is it worth it to them to be spending several $1,000s more on another action? Um, Ending support on the basis of cohabitation, which is the term that's often used in separation agreements and divorce decrees, can be very difficult to prove, one, and very expensive as a result. In order to prove cohabitation, you have to prove much more than the former spouse and their paramour are simply spending time overnight together. Even if they're doing it all the time, this can be difficult if there is a separate apartment that is kept by each of these new lovers. So, in this instance, if the ex husband is keeping his own apartment, he's going to be able to demonstrate, more likely than not, that he is still keeping a separate place, that he and the new girlfriend have not actually started to commingle their assets and operate as if they were a husband and wife working out of a single pocketbook. These are the factors that a court is going to look at when determining whether or not a former spouse is now cohabiting with their new girlfriend or fiance. Um, Now, obviously, if these two people had gotten married, this becomes a no brainer. That's much easier to show. This also depends, last point, on the language in the divorce decree or the separation agreement. You can find this language in either place depending on what the attorneys did in the original divorce action. But it has to make sure that the court has, in fact, retained jurisdiction over spousal support. That's something the court has to specifically do under Ohio law. And then, second of all, does it define cohabitation? Sometimes a smart attorney will be sure to very specifically define what they mean by cohabitation. And in that instance, it's that language that's going to inform the court at a later date as to whether or not cohabitation has occurred. Please smash that like button. Be sure and leave your comments for me. Again, I'm Todd Kotler. I'm an attorney with Gruber, Haren, Thomas and Company in Canton, Ohio. If you leave your comments for me, I will be sure and leave my contact information so you can get a hold of me if you have further questions and live in Ohio and need to hire an attorney here. Till then, I look forward to seeing you again and have a great day.